All right, good morning. Welcome to the 294th District Court. My name is Chris Martin. I'm going to call this morning's docket. When you hear your name, please say present or here. Ricky Sanchez, Jennifer Rollins, Claude Souls, Monty Austin, anxiety or stress or what is it?
It's sort of head trauma.
Head trauma?
Yes, sir.
Bryce Carroll, Billy Ray Clark, Amanda Reyes, Diego Sharkus, Mr. Powell set for 11. All right, do we have anyone that has any agreements or is ready to go? Counsel, Mr. Bingham?
Yes. On Jennifer Rollins.
Ms. Rollins, come on up. This is cause number CR 22-226, State of Texas versus Jennifer Danielle Rollins, motion to revoke. I believe that we had you set on hiring an attorney. Is that correct? That's what we were set for today. I see that Mr. Bingham is here. Mr. Bingham, I'm just assuming that you want to reset unless you've already got something worked out.
Yeah, we asked for a reset date. I was paid a week ago today. We were asking for July 9th reset. We'll be ready at that point. We signed the form.
Are you anticipating a contested hearing, or do you want a status? Because what I can do is I can set it for July 9th, and then I could set it on the contested docket July 30th. That way, if you don't reach an agreement on the 9th, we could have the hearing on the 30th. That work? All right. All right, Ms. Rollins, thank you for doing what you said you were going to do and hiring an attorney. All right, court sets Ms. Rollins for status hearing on the motion on July 9th. And then we'll also set it on the contested docket if there is no agreement for July 30th.
Yes, I appreciate it.
Yes, sir. Good to see you. Y'all free to go? Yeah, yes, sir. Mm-hmm. Yeah. Oh, yeah, he's here. Yeah. All right. We have anyone else that's ready? See no takers. Ricky Sanchez, CR 16149. All right, Ms. Sanchez, show that we were set today on a status on whether or not you've hired an attorney. Go ahead.
I have been on probation 6 years.
So you want me to explain to you why you're here?
You know, I know, but I want. I have got my seats sitting. I've got on my feet. I see.
Well, the state of Texas has not tendered a motion to dismiss their motion to revoke. So yes, you're going to have to either A, hire an attorney, or B, represent yourself, or C, if you cannot afford one and you believe that you're indigent too poor to hire an attorney, then you can ask for a court-appointed attorney.
Just can't do it. They just find us. And he got until the first to make up for the first payment, which is unfortunate. So that's my situation.
All right, State, do you have anything to add on this motion for Ms. Sanchez?
Your Honor, I don't really have anything to add. I've just briefly looked over it and see that it's her. But while it says felony 3 here, it looks like it was her misdemeanor. I don't know if that changes the situation at all. But I don't really have any,
Have you talked with probation yet about Miss Sanchez's case?
I have not, Your Honor. Here's that this has been, sitting for some time.
All right, well, let's do this, Miss Sanchez. Why don't you just have a seat and let's let the state have an opportunity to talk to the probation department and get their bearings, and then perhaps we can go forward today. Right, that's what I'm saying. This gentleman here, and this lady here,
So I've been on 6 years.
I understand.
needed to get this straightened out.
I understand. And so what I'm telling you is, if you'll just give me a few minutes, have a seat, let Mr. Hartwell, Ms. Burns talk about the case, and then we can direct you further. All right, so I'll recall her case in a little bit. All right, Mr. White, who are you ready on?
Uh,
Mr. Carroll, if you'll come forward, cause number CR 21208. And let's see, we're set for hearing on the motion to revoke today.
That's correct. What we are asking, and I believe the state agree with this, is that, one of the allegations is a, new offense that occurred in Charas County, which, was probably somewhere around 3 months ago, but still has not had anything at all happen. We are asking for there to be, and I think the state agrees that we have like 2 months on this and see why it's going on that, come back, and try to do anything. Obviously, the logistics of, anyone from Travis County coming here is somewhat a problem. And if nothing happens, occurs, that also may have some bearing on this.
State.
Your Honor, there, that is one of the driving, alleged violations is the new arrest. I think it might, and depending on how that case goes, could significantly impact how we proceed on, MPR.
So if I said it one more time, we're either gonna have a disposition or you're gonna withdraw it.
Yes, sir. Should be able to,
July 30th, Mr. White. All right, court is going to set Mr. Carroll for a final hearing on the state's motion to adjudicate on July 30th. Yes, you're excused, Mr. White. Thank you, sir. All right, Mr. White, are you ready with Mr. Sharkus? Diego Sharkus, if you'll come forward, please. Ms. Burns, do you need that completed? Does he need to fill that out before we do probation? I mean, I got your conditions. All right, this is cause number CR 23-205, State of Texas versus Diego Isaiah. Is it Charkis or Sharkus? Charkis? All right, Mr. Charkis, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today would be the truth, the whole truth, and nothing but the truth, so help you God? You can lower your hand. All right, Mr. Charkis, just make sure you speak up loudly and clearly for me, okay? Your name is Diego Isaiah Charkis, correct?
Yeah.
And Mr. Charkis, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
Your Honor.
Okay. Are you currently on any type of medication or treatment for that?
No.
All right. And your dyslexia, has it become any kind of impediment or trouble for you in trying to understand and read your plea agreement today? All right. And throughout this case, you've been represented by your attorney, Mr. Nolan White, correct? And are you pleased with what Mr. White's done for you as your lawyer? You feel like you've had enough time to talk with him about your case to the point that you understand all of your legal rights and everything that you have read and signed in the plea papers? And where you have signed, Mr. Charkis, is that your true and correct signature, and that you only signed once you were competent, or once you were confident that you understood what you were signing? Mr. White,
Yeah.
do you believe that Mr. Charkis is competent today?
Yes, sir, I do. And as far as, we've had no problem. As far as, like, impediments or anything like that.
Okay. And you've explained to Mr. Charkis the advantages and disadvantages of a deferred adjudication plea?
I certainly did, Your Honor. I explained to Mr. Charles, if he violates anything, he'll be at the court's mercy. They show about fines that we shouldn't be as out of probation. Court consents him up to a year to county jail. And $4,000 fine.
Now, Mr. Charkis was originally indicted with something other than what he's pleading to today. Is that correct?
That is correct.
What was he originally indicted with? I don't have an indictment here.
We had a firearm that was school.
Okay. All right. And Mr. Charkis, today it looks like the proposed plea agreement would be to a lesser offense of unlawful carrying of a weapon, a Class A misdemeanor. And a Class A misdemeanor does have a range of punishment of confinement in the county jail up to a maximum not to exceed 365 days, and a fine, if imposed, of not more than $4,000. And I see the plea agreement is that you would be pleading guilty to that crime today in exchange for the state's recommendation that the court not convict you, but rather place you on 15 months of community supervision with a $500 fine plus court costs and reimbursement fees. And the state would be dismissing their terroristic threat charge in cause number CR 23206. And you would be agreeing to forfeit the Taurus 9mm a handgun that was used in this offense. Is that your understanding of the plea agreement, Mr. Charkis? All right, understanding the plea agreement, understanding the range of punishment, Mr. Charkis, how do you plead to the lesser included offense of Class A misdemeanor unlawful carrying of a weapon? Are you pleading guilty to that crime because you are in fact guilty of committing that crime? Has anybody threatened, forced, or pressured you to plead guilty? All right, the court will accept the defendant's plea of guilt. Mr. White, any objection to the stipulation of evidence?
No.
All right, stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state? Anything further from the defense? All right, court's reviewing the stipulation. All right, based on the court's review of the evidence, I find enough evidence to convict the defendant of this offense. The court follows the plea agreement and the recommendation from the DA's office. The court hereby defers the finding of guilt on unlawful carrying of a weapon, a Class A misdemeanor. Court places Mr. Diego Isaiah Charkis on community supervision for a period of 15 months. Orders him to pay a $500 fine, $270 court costs, and $35 in reimbursements. Court also dismisses under section 1245, cause number CR 23206, terroristic threat. And the court finds that there is an agreement and does hereby order the forfeiture of the 9mm Taurus black silver handgun that was used in this offense. State, is there not a serial number that can be listed in this special finding so that the evidence clerk, because I can only imagine there might be a lot of 9mm black and silver handguns.
Yes, Your Honor, let me see if I can find it.
All right.
Anything needs to be changed. Like serial number.
All right, thank you, Mr. Wright. Yes, Mr. Hartwell, I would like something, a better descriptor in this so that the evidence clerk will know exactly what weapon is being forfeited so that they can dispose of it properly.
Your Honor, I do have a serial number here.
Right.
T is in Tom, E is in Edward, X is in X-ray, 45031.
All right, so the serial number for the 9mm black silver Taurus handgun is serial number TEX 45031.
Yes.
Thank you, sir. All right, Mr. Charkis, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm going to have you come forward to be fingerprinted with Deputy Martinez. After that, you'll meet with the probation officers in this room over here, and they'll give you more information. Yes, thank you, Mr. White. Do you have anything this afternoon? Have a good afternoon. Sorry. All right, court calls, cause number CR 24108, State of Texas versus Amanda Reyes. All right, Ms. Reyes was originally set today for pretrial release non-compliance. The court finds that Ms. Reyes has been indicted in cause number CR 24108. At this time, let's go ahead and address the arraignment. Mr. Schmidt will get that set, and then we'll talk about the non-compliance issues.
Yes, sir. Did receive a couple of charges. And the range of punishment, we waived one reason of that. Currently not getting the gas to start to free up. In general, I think that the processing that so I think.
All right, court finds that Ms. Reyes, having waived the formal requirements of arraignment, enters her plea of not guilty into the record. Court will set this matter for pretrial hearing. Mr. Schmidt, I've got, it's not much later. I got July 9th, or the next date would be August 13th. That's fine. All right, court sets Amanda Reyes for pretrial hearing August 13th at 9 a.m. All right, Mr. Schmidt, we'll take up the issue of the alleged non-compliance with conditions of pretrial release. Mr. West, if you'll come over, please. All right, Mr. West, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today would be the truth, the whole truth, and nothing but the truth? So help you God. All right. And what is my, do me a favor, will you turn on this computer right here? Here, I'll Just click that button right there. Okay, good. Mr. Westfield, back up, get on camera. There we go. All right, Mr. West, as the court's pretrial supervision officer, do you know Miss Amanda Reyes?
Yes, sir.
And Miss Reyes has been supervised by your department, is that correct?
Yes, sir.
And in your supervision, Miss Reyes, did you come to an occasion to have her tested for any illegal or controlled substances?
Yes, I did.
Can you tell me about that?
On April 27th, or about April 27th, she was tested for illegal drugs, she was tested positive for marijuana. And she did admit to the use of marijuana.
All right, was there any more conversations regarding the use of illegal or controlled substances such as marijuana?
No.
Okay. All right, any questions for Mr. West? Mr. Schmidt?
As far as marijuana. From my understanding, when the 2069, and Ms. Reyes provided a sample. And that testified for marijuana well. And the department send that sample for confirmation. Sure. I think that. So I just, after the meeting, she stopped using, it's possible that it's still be possible today instead of that. Thank you.
Any questions from state? Thank you, Mr. West. All right, Ms. Reyes, you were fully aware that you had conditions of pretrial release, correct? You were fully aware that you were prohibited from smoking marijuana while you were on conditions of pretrial release, is that correct? And you understood that there's a potential consequence that the court could revoke your bail in this case and put you back in jail. Do you work? Do you work full-time? Do you have kids? Do you support your kids? How are you going to do either one of those if you're sitting in this jail because you don't listen to what I tell you to do and you smoke marijuana? How are those two things going to happen? They're not going to happen. Who's going to raise your kids while you're sitting in jail? No one? Well, someone will. It's called it's called CPS. CPS would swoop in, pick up your kids. You can't get your life together. They'd move to terminate your rights and give your kids to someone else who is going to take care of them and not smoke weed and do those things. You understand that? I hope this is a wake-up call for you. I mean, this. Mr. Schmidt has asked the court to withhold revoking your bail today and to give you an opportunity to come back and test again and to prove to this court that you are taking serious what your conditions tell you to do. I'm going to grant Mr. Schmidt's request. But don't think for a second that the next time you come in here with a violation that it's going to be the same. I hope you do. All right, we're going to see you back on August 13th at 9 a.m. Sign your reset and you're free to go.
Your Honor, I'm sorry, I don't think that you are in the sign. You're just ready to out of county.
Were you arrested somewhere outside of Van Zandt County? Wood County? All right, I'll tell you what, stay here for just a moment. I need to get you an order that's going to tell you to go out to the Justice Center, to the jail, and they just need to get your fingerprints. They're not going to change you out or anything. You'll take the order in there with your ID, tell them who you are. They're going to take your fingerprints. Yeah, you're going to go to the Van Zandt County Jail. Because you were arrested there, we didn't get your fingerprints here, and we're required to report that to the state. So just have a seat in the hallway. We'll get an order. We'll bring that to you, and then take your ID, go out to the jail when you leave and get that done. All right. Ms. Abraham, can you get me a TRN order for Ms. Reyes? She'll be out in the hallway waiting on it. Mr. Hartwell, do we have any progress on Miss Sanchez?
Your Honor, I'm pleased to see with probation. It appears there are some outstanding balances.
Ms. Sanchez, come on up. This is cause number CR 16149, State of Texas versus Ricky Lee Sanchez. Go ahead, Mr. Hartwell.
Your Honor, and just to address kind of today, I did have an opportunity to briefly speak with Ms. Sanchez in the fall. Let her know that at this time, I'm not allowed to communicate directly with her. I did not communicate that she could hire an attorney, request an attorney for waiver hearing. I did not communicate any of that to her. Only that at this stage, I'm not allowed to communicate directly. In speaking with probation, it looks like there is an outstanding balance along with potentially a class that would be completed for DPS. So as far as resolving the cases, it looks like we would move forward. But like again, without having the opportunity to speak with Ms. Sanchez or the attorney on her behalf, I don't know exactly what.
Is it a class A or a class B?
Class A.
Class A, okay. All right, Ms. Sanchez, so you have an option here today. If you want to have a discussion with the state of Texas, they are not allowed to speak with you until you either have an attorney or you waive your right to an attorney and you seek to represent yourself. But later you could do that. You could waive your right to attorney and you could see what the state has to say, look at their file, do those things. And you can always later decide after the fact that if you don't like what they say, then you can still hire an attorney. It's not a waiver that is infinite. Yeah, I don't want to discuss the evidence. He's not telling me what he's going to prove, and I don't want you to tell me what you're going to defend. So in order to do that, I'm going to have you fill out a form so that you can understand what waiving your right to an attorney means at this time.
Could you just reset? And
I can do that. So you don't want to waive your right to an attorney, talk with them today, decide what they're offering, decide if you can clear up any of those things.
yeah, let's see.
All right, so that means I'm gonna have to have you fill out a form. We're gonna have to talk about it, go over it, because I have to assure you that you know what your rights are and that you're waiving those to speak with the attorneys.
Temporary.
It can be temporary or it can be permanent. It's your choice. It's your choice. It's not like you waive it today and then you're not allowed to have an attorney later. Okay. All right, have a seat. I'll get some paperwork together. We'll have you go through it, read it, sign it. We'll come up, you and I will talk about it, and then that'll allow the state to talk with you. You're welcome. Come up. All right, this is in cause number CR 16149, State of Texas versus Ricky Lee Sanchez. All right, Ms. Sanchez, regarding your waiver of right to counsel and request to allow yourself to communicate with the attorneys representing the state, the prosecution, I want to go over a couple of warnings and admonishments. You understand, under the Sixth Amendment, you have the right to counsel. You understand that? You have the right to hire an attorney, and that's an attorney of your choosing. You also have the right to request a court-appointed attorney if you are too poor to afford one. I believe earlier you said that you do have the ability to hire an attorney. That's fine. You also have the right to waive your attorney, and that's not a permanent waiver. You have the right to waive the attorney at this time to speak with the representatives from the DA's office. And then you also have the right later to assert your Sixth Amendment right and hire an attorney. So if you waive your right today, you can speak with the attorneys. And if you decide later that you want to hire an attorney, you have that right as well under the Sixth Amendment. Yes, ma'am. Yes, ma'am. I do want to admonish you, though, that if you do waive your right to counsel today and you speak with the attorneys representing the state, that anything that you say to them, they may be able to use against you at your hearing later with or without an attorney. So you should be mindful of that in your discussions with them. Okay, so understanding your right to counsel, understanding your right to waive it, your right to reassert it at a later time, and your right to waive it and speak with the attorneys for the state. Do you want the court to approve your waiver? All right. Court finds that Ms. Sanchez has been admonished with regards to her right to counsel, that she's intentionally, knowingly, and voluntarily waiving her right to an attorney at this time to speak with the DA's office. The court approves that. And Ms. Sanchez, where you have signed here on this document, is that your true and correct signature? And you only signed that document once you were confident you knew what you were signing, correct? All right, court approves the waiver of right to counsel. We'll provide a copy to the state so that you can speak with Ms. Sanchez. All right, Ms. Sanchez, go ahead and have a seat, and the attorneys will be here. You got the original? Forgot to sign them. Yeah, I got to sign before they did that. All right, court's going to stand in recess for 20 minutes, allow counsel to work.
I think we have.
All right, 20 minutes. All right, Mr. Schmidt, who are you ready on, sir? Is this a plea? All right, this is cause number CR 21-34, State versus Bobby Joe Richards on motion to revoke. Go ahead, Mr. Schmidt.
Seen it or I'm not aware of the contents. I believe that indictment.
That's correct. It's just another one that, looking to just stated the record, so. I believe we did get it approved, but I don't think it's finished being processed yet.
All right, so there's a request by the state and the defense to reset Mr. Richards.
Yep.
How long do you want to reset this motion to revoke?
Let's see, since the indictment just came through on that.
What's he indicted for?
Injury.
All right, let's set it on July 30th for status.
30th?
July 30th. July 2nd. Do you, all right, yeah, we'll set it on that July 2nd. Likely may have the new indictment set for arraignment at that same time. Indictment did come out on May 17th. All right, Mr. Richards, motion to revoke is set for hearing on Tuesday, July 2nd. Who's next? Just have him come. No, that's fine. No, just have him come right that way. Mr. Hernandez. Ari Hernandez Mendoza. All right, Mr. Hernandez is set for arraignment today. Court finds that Mr. Hernandez waiving the formal requirements of arraignment enters his plea of not guilty into the record. We set this matter for pretrial. Do you want that July 2nd or something later? All right. Set for pretrial July 2nd at 1:30, unless he makes bail. Joseph Cronin. All right, this is cause number CR 22-322, State versus Joseph Paul Cronin, motion to revoke. Go ahead, Mr. Schmidt.
One.
How long do you want, Mr. Schmidt?
I
Okay. Court sets Mr. Cronin for hearing on his motion to revoke July 2nd. That will not be a evidentiary date, so it'll just be an announcement. You ready for next this one?
Whichever ones you want, there's two there.
Mr. Pezel? All right, this is cause number CR 21-183, State of Texas versus David John Pezel. Mr. Pezel, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can lower your hand. All right, Mr. Pezel, you appeared before the court on August 10th, 2021. You pled guilty to the second-degree felony offense of aggravated assault with a deadly weapon. Court heard the evidence, found enough evidence to convict you, but the court found that the state recommended that you be placed on deferred community supervision. The court approved that recommendation and agreement and placed you on 5 years of community supervision. Your community supervision was also extended for an additional 1 year. And it was during that period of your community supervision that the state filed its motion to adjudicate and revoke on January 18th of 2024. In that motion, the state has alleged 6 separate counts of violations. Have you had enough time to review that motion and the counts with your attorney, Mr. Schmidt? Are you pleased with Mr. Schmidt and the work that he's done for you? Are you pleased with Mr. Schmidt and the work he's done? And do you feel like you understand everything that you've read and signed as part of your plea agreement? Mr. Schmidt, does your client waive the formal reading of the state's motion? Does he intend to plead true to all 6 counts?
Yes.
All right, Mr. Pezel, I see that the agreement in your case is that you, upon your plea of true to those 6 counts, the state's recommending that the court adjudicate your guilt, convict you, revoke your community supervision, and assess punishment at 5 years in prison with remainder of your fines and reimbursement fees, and you would receive 303 days credit towards your sentence for the time that you've already been in jail. Is that your understanding of the plea? That's what you're asking the court to approve? All right, Mr. Schmidt, do you believe Mr. Pezel is entering into this plea with competency and that he's doing so intentionally, knowingly, and voluntarily?
Yeah.
All right, Mr. Pezel, how do you plead to counts 1, 2, 3, 4, 5, and 6? Are those counts true or not true? And you're telling me that they're true because in fact they are true, correct? All right, and has anybody threatened or forced or pressured you otherwise to plead true to any of these counts? All right, the court does accept the defendant's plea of true to each count. Mr. Schmidt, any objection to the evidence supporting the plea?
Okay.
The defendant's plea of true and waiver of rights is admitted, and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing.
Anything further from the defense, Mr. Schmidt? All right, then based on the evidence before the court finds that Mr. David John Pezel has violated the terms and conditions of his community supervision. The court finds the allegations to be true. The court this day follows the recommendation and plea agreement. The court adjudicates the guilt, convicts Mr. Pezel of aggravated assault with a deadly weapon, revokes his community supervision, assesses punishment at 5 years confinement in the Texas Department of Criminal Justice, orders him to pay the balance of his financial obligations, and awards him 303 days credit towards his sentence for the time that he has spent in jail on this cause. All right, Mr. Pezel, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you come forward to be fingerprinted. Deputy Martinez, can you do that for me? Come on up here, right by the computer there. Christopher Gage. All right, this is cause number CR 13-247, State of Texas versus Christopher Matthew Gage. Mr. Gage, sir, if you'll raise your right hand, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Thanks, sir. Lower your hand, just speak up loudly and clearly for me. Mr. Gage, you appeared before the court on November 28th of 2017. You pled guilty to evading arrest or detention with a vehicle, a third-degree felony. The court heard the evidence and followed the recommendation of the state. In your plea agreement, the court did not convict you. The court placed you on deferred community supervision for 4 years. And it was during that period that the state filed its motion to adjudicate, alleging what appears to be 5 counts of violations. Have you had enough time to review that motion with your attorney, Mr. Schmidt? Are you pleased with Mr. Schmidt and the work he's done for you? Do you have any questions about the plea agreement or anything that you signed? Mr. Schmidt, do you believe Mr. Gage to be competent?
I do.
Does he waive the formal reading of the motion?
Yes.
And does he intend to plead true to all 5 counts?
Yes.
All right, Mr. Gage, I see the plea agreement in your case is upon your plea of true to the counts as alleged. The state's recommending that the court adjudicate your guilt, convict you of evading arrest or detention with a vehicle, revoke your community supervision, assess your punishment at 3 years confinement in prison with the balance of your fines and court costs, and that you would receive credit time of 1,095 days towards your sentence. Is that your understanding of the plea agreement? All right, Mr. Gage, then how do you plead to counts 1 through 5? Are those counts true or not true? And you're telling me that each one of those counts is true because they are true, not because you're just trying to get a plea agreement, correct? All right, court. Well, and Mr. Gage, has anybody threatened, force, or pressured you to plead true? All right, the court does accept the defendant's plea of true to each count as alleged. Mr. Schmidt, any objection to the admission of the defendant's waiver of rights to plea of true? That is admitted, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further on that.
Anything further from the defense?
No.
All right, then based on the evidence today, the court finds that Mr. Gage has violated the terms and conditions of his community supervision. The court will follow the plea agreement today. The court adjudicates Mr. Gage of evading arrest or detention with a vehicle, a third-degree felony, revokes his community supervision, assesses punishment at 3 years confinement in the Texas Department of Criminal Justice, orders him to pay the balance of his financial obligations, and awards him 195 days credit towards his sentence for the time that he spent in jail on this cause. Mr. Gage, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you step forward up here to be fingerprinted with Deputy Martinez.
Exactly. 195 days, correct. Did you misread that?
Oh, I'm sorry.
I know the judge is correct.
1,095 days. That's a big difference, isn't it, Mr. Gage? Yeah, that's something we want to stop and be certain about, don't we? Yes, if I said 195, I apologize, correct the record. 1,095 days. We have paperwork on our 11 o'clock, Mr. Powell.
Your Honor, I believe Mr. Bird is working on this. But otherwise.
Mr. Manning, you ready? Are you ready on?
So,
Mr. Souls, if you'll come forward. This is cause number CR 21-246. State versus Claude Raymond Souls, motion to revoke. Okay. There's a coup word. Okay. Go, Mr. Manning.
Judge, we appreciate the probation department, that Mr. Soul, they agreed to take Mr. Soul back on probation. Additionally, Judge, as a sign of good faith, Mr. Soul today has paid off his, fines, court costs, as well as the balance of probation fees. And so, his only remaining fees will be, his probation and supervision fees as he go forward from this point. Additionally, Judge, I was informed that Mr. Souls had a negative hair follicle test from April. That's what we were waiting on. That was the reason we said it for so long. After talking to probation, talking to him, he did have a negative, and so their suggestion was that he continue having the hair follicles for the remainder of his probation, probably 2 or 3 more before he expires their finals. His progress is made. Additionally, Judge, the reason we argue the hair follicle is because of his medical condition. He is unable to provide a urine sample. But as I said, he did provide the -1 in April, and he is prepared to pay the additional expense for this hair follicle.
So states withdrawing their motion and continuing.
Yes, Your Honor, and if I would compare that one.
All right, then court will grant the state's motion to withdraw the motion to revoke and to continue Mr. Souls on community supervision. And as soon as that's produced by the DA's office, I'll get that signed. So Mr. Souls, you're free to go and check in with your probation officer before you leave today. Did y'all agree? Did y'all agree to amend for new costs or anything, attorney fees, or
Your Honor, we never even discussed it.
that's something that needs to be discussed? If there's going to be new attorney fees for your appointment, reimbursement,
Yes, Judge.
do we want to just reset Mr. Souls to come back in 30 days and get all that done, or?
I prefer not, just due to where he is in his treatment. I'll do Mr. Cole, that is wrong.
Okay.
Judge. Judge, ready on your Tyler Donovan?
Tyler Scott Donica, CR 21-285. Go ahead, Mr. Manning.
Judge, the agreement, that we've reached is that the state's going to withdraw and continue, with the amendments to Mr. Donovan's conditions that, he had, he would be placed on a mental health, caseload, and back time credit will be, eaten up.
Back time as a condition of community supervision.
That's correct.
And Your Honor, I'll have that one prepared as soon as I have the run the numbers on the bank.
Is that something we're doing today, or? Okay, so just do it later this afternoon, or?
That's fine if we wanna.
Okay. All right, all right. Court will recall Mr. Donica then later this afternoon when we get the paperwork done.
Judge, just for record purposes, we have reached an agreement with Mr. Mays, and I believe the state is attempting to do paperwork for after.
Okay, all right, we'll recall him this afternoon.
And Judge, if we may, on Mr. Clark. I think we're ready to.
How about Mr. Clark?
Judge, I was provided a notice recently that he was going to be set for, compliance hearing on conditions of pre-trial release.
Oh, Billy Ray Clark.
Yes.
All right, yes. Mr. Clark.
Yes, sir.
Oh, there you are, sorry. All right, give me a second. Let me flip over here. All right, this is pre-trial release compliance hearing regarding Billy Ray Clark. Any announcements, Mr. Manning?
Yes, Judge. We reached an agreement in terms of this compliance. However, during our discussions, it came to my attention that this case is going to be handled by Mr. Hall, who was extended a pre-trial, a pre-back offer that my client just to accept. We would request, and I don't know the logistics of this, but we would request that be reset for a month for him to come back and do that plea. We'll need to file information as well as do the pre-indictment discovery. But that's our intention for the plea in one month's time.
Is that going to be to a misdemeanor downstairs or is that to a felony up here?
State jail felony. That's the, just, I don't know if I'm gonna indict it and go downstairs or upstairs. I just, like I said, was informed that there is a way that conflict ending.
Yes, Your Honor. So, the evidence would support a state jail. So per the document order, we intended to file that downstairs. He was arrested on a third-degree compliance for 48 today. But after reviewing the evidence, it would be a city jail. And Mr. Hall, I do know, did extend a pre-indictment offer. Spoke to Mr. Manning about that, so that is the understanding.
And is Mr. Hall aware of the allegation of his non-compliance?
Yes, Your Honor, and I believe that's what spurred Mr. Hall to look at the case and extend the pre-indictment offer.
All right, Mr. Clark, I'm going to reset this compliance hearing for 30 days and give the state an opportunity to see if they can resolve your case all together. If it's not resolved, then I'm going to take up this matter of whether or not you violated your conditions of pretrial release by being arrested in Wood County for criminal trespass.
And Your Honor, since it is a state jail, would you prefer it for being up here to be resolved or transferred to the
It doesn't, well, it's not filed, so there's no transferring anything yet. So right now, I'm the only one that can deal with his conditions of pretrial release because I'm the issuing magistrate. So I'm just going to reset this for pretrial release. If y'all want to file it downstairs and Mr. Hall handle it down there on his docket, I have no problem with that. I'm just going to set it up here. If it gets pled out down there, great. You'll let me know. We'll remove it from the docket.
Thank you.
Judge, what day we're looking to set that?
Tell you what, to give Mr. Hall time, I will set it July 9th. Are you available that day? I'm sorry, not 9th, 11th. That's a Thursday. Are you?
I believe that's fine. Just double check. July 11th, that'll work.
All right, court says Mr. Clark on his pretrial compliance hearing July 11th at 9 a.m. If this case gets resolved downstairs, or if it gets resolved downstairs, then just notify Ms. Taberham and we can remove this off the docket.
Thank you.
You're welcome, sir. Who's next, Mr. Rain?
Judge, just for record purposes, I believe that Mr. Mata will be transferred over from County. And so, I believe we're resetting, and I just don't have a date.
All right, let's reset Mr. Mata. We'll try to bench warrant him again. Can't remember what Ms. Abraham told me was the issue as to why we didn't get him.
Judge, I actually think he's being held on a hold. Like, he's in bands and, but held in.
Set him for the next contested docket, which is June 20th. A contested hearing.
Judge, I haven't had an opportunity to speak to my client. He had a previously absconded, and had been recently arrested. I have not had an
Okay.
opportunity to.
We'll just leave it on that contested docket, June 20th at 1:30.
To June 20th.
20th, yes.
Judge, I believe the last one I have this morning is Mr. Watkins.
Michael Watkins. All right, this is cause number CR 20-201, State versus Michael Watkins. Motion to revoke. Go ahead, Mr. Manning.
Yes, Judge. I spoke to the additional witnesses and have looked at some of the information that was provided to me on Mr. Watkins' case in preparation for not only this this hearing, but also some underlying issues. I have not had an opportunity though to reach out to one witness. I think it's going to be vital to determine how we proceed going forward. And so I request an additional reset on Mr. Watkins' case due to the new information that I've just received from the witness.
Your Honor, additionally, Officer Charas is not available today. It would be necessary for the state to proceed. I apologize for not putting in a motion to continue earlier, Your Honor, but the state would not be able to proceed today.
All right, court sets Mr. Watkins for a final hearing on the state's motion on June 20th.
And Mr. Watkins, excuse me.
Yes.
I believe that includes what I have this morning. Do we know if the female will be brought up in jail or should be that?
I'm not sure that we're going to have time to bring them over before lunch. So I would anticipate they would just be this afternoon.
In that case, that would be.
Yes, sir. All right, go ahead.
We call Ms. Sanchez.
Yes, I was about to ask. Ms. Sanchez, come on up. All right, this is cause number CR 16-149, State of Texas versus Ricky Lee Sanchez. Go ahead, Mr. Hernandez.
Thank you, Your Honor. I've had an opportunity to speak with Ms. Sanchez, and I think some of the confusion was cleared up. She has in fact paid all of her fines for costs, zero balance. The $1,260 over probation costs, and I've advised her of that. She just needs, about a week's more of time. She intends to make one payment. Take care of it. Told her that once she did that, in consultation with attorneys, that we would file a motion to withdraw, a motion to revoke. But to her credit, Ms. Sanchez said she'd like to come back to make sure that the case is closed and she won't have anything else that to worry about.
Okay.
So if we could reset it for the next court date, giving her at least 2 weeks, for her to make that payment, that should take care of it.
Ms. Sanchez, I could bring you back on either June 13th or June 20th. Which one would you prefer? 20th? All right, court sets Ms. Sanchez to June 20th. And I need a. It's all right, I'm already into it. All right, Ms. Sanchez, if you'll come forward right up here. I'm gonna have you sign this reset notice. It just says that you're gonna come back on the 20th. We'll have that compliance hearing. If you'll sign that, I'll give you a copy. All right, we'll see you back then.
Thank you so much.
You're welcome. Mhm. Give me a second, I'll tell you. You need Gerald Powell. Okay, he's got to stay. Yes, fine, Richard. And I think Jonathan's done. Find Richard and find out if he needs any of his, because I don't know who's back there. All right, everybody else can go back till this afternoon. Okay, all right. All right, we are on the record in cause number CR 21-235, State of Texas versus Gerald Wayne Powell. Mr. Powell, just where you're sitting, if you'll raise your right hand, place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you, sir. You can lower your hand. All right, Mr. Powell, you're here before the court on a plea agreement today. I got to ask you a series of questions. Mr. Powell, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
And have you ever been diagnosed with any type of mental condition? And are you under, can you tell me about that? What have you been diagnosed with? All right. And are, yeah, I was going to question you about that in just a moment anyway. And Mr. Powell, are you currently on any kind of medication or undergoing treatment for those disorders? All right. Do you feel like you have a clear understanding and a clear mind today regarding these proceedings and what's going on in court? In this case, Mr. Powell, you are represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the work he's done for you? Do you feel like you've had enough time to discuss your case with him, that you've had all of your legal questions answered, that you understand everything that you've read and signed in your plea agreement? Do you have any questions before we go any further? Mr. Schmidt, this would be the time I was going to ask you about Mr. Powell's competence. Go ahead.
Well, just the court's aware. That was based on conversations that we had, attorney-client conversations. And the status of the time, throughout my dealings of a little over 3 years, I've never done this competency. I've never had an issue of competency per se, but for procedural purposes, and that notice of intent to seek the exam, that's the state has had Mr. Powell evaluated by forensic expert. In addition to that, we retained and had Mr. Powell by my own forensic expert pertaining to the status of the insanity at the time of the commission of the offense. Both the state's expert and our expert came to the same conclusion that we did not believe the criteria for insanity. Although it did cite likely mental illness, it did not reach that level to substantiate that problem. At this point in time, we would withdraw that notice with intent to seek insanity, withdraw our rights pertaining to a contest on that issue as the court proceeds.
Thank you, Mr. Schmidt. Furthermore, have you explained to Mr. Powell his rights regarding this case and what this plea agreement means for him?
Yes, sir.
And do you believe that he understands your admonishments and your advice, and that he's entering into this plea intentionally, knowingly, and voluntarily? Thank you, Mr. Schmidt. All right, Mr. Powell, you are charged by indictment with a first-degree felony offense of murder that does carry a range of punishment if convicted to not less than 5 years or more than 99 years or life confinement in the Texas Department of Criminal Justice, and a potential fine not to exceed $10,000. I see the plea agreement in your case, and the recommendation from the state is that upon your plea of guilty, that the court convicts you, and the recommendation is that sentence be assessed at 25 years confinement in the Texas Department of Criminal Justice, no fine, no restitution, court costs of $290, reimbursement fees of $25, and you would receive jail time credit towards your sentence in the amount of 1,144 days for the time that you've already spent in jail on this case. Is that your understanding of the plea agreement?
Yes, sir.
All right, Mr. Powell, then, understanding the range of punishment, understanding the plea agreement, at this time, I would ask you, how do you plead to the first-degree felony charge of murder? Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
And Mr. Powell, has anybody threatened, forced, or pressured you to plead guilty?
No, sir.
All right, the court will accept the defendant's plea of guilt at this time. Mr. Schmidt, any objection to the evidence supporting the plea?
No.
All right, the stipulation of evidence is admitted, and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
No.
is the victim's family, is the DA's office in compliance with victim notification, and is the victim's family supportive of the plea? And if you can turn your mic.
Notification. Or to the second question as to whether they are in support of the plea. The victim is survived by this defendant, of course, who is her son, and two other adult children. Her daughter, Pamela Fowler, is supportive of the plea. Her son, Jason Powell, is not, Judge, and quite frankly, this plea is a bitter pill for me as well. I can certainly understand both sides, both Ms. Fowler and Jason Powell's positions. I've been in the criminal justice system for 30-something years. I have never, ever seen a crime scene even close to this. To me, this offense deserved a higher sentence than what we've agreed to here. The reasons for making the agreement that we have here and asking the court to accept that agreement in spite of the fact that I think the conduct is deserving of a more harsh outcome. The investigation that was presented to us by the sheriff's office at that time, and the leader of the sheriff's office at that time, was not such that we could go forward confidently to trial. As this court is well aware, some of the members of that department are now incarcerated. And that is all what went into us making this decision. So, in all candor with the court, Mr. Jason Powell is not supportive of this plea. Pamela Fowler is supportive of this plea. She understands our reasons. We have given those reasons to Jason Powell. But we are in compliance and are asking the court to accept the plea.
Thank you, Ms. Curry. Anything further from the defense, Mr. Schmidt?
No.
Okay. Court's going to review the stipulation of evidence. All right, court, having reviewed the evidence, finds that there is sufficient evidence to convict Mr. Powell of murder. The court will follow the plea recommendation at the request of both the defendant and the state of Texas. Court hereby, following that agreement, finds Gerald Wayne Powell guilty of murder, a first-degree felony, assesses punishment at 25 years confinement in the Texas Department of Criminal Justice. The court orders him to pay court costs of $290, reimbursement fees of $25. Further, the court awards Mr. Powell jail time credit of 1,144 days towards his sentence for the time that he has already spent in jail on this cause. All right, Mr. Powell. Court having imposed sentence, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Deputy Martinez, if you'll come and secure this judgment and take the fingerprint of Mr. Powell, then you can take him back into custody. Just curious, my understanding that there was a request for victim allocution, however, a misunderstanding as to whether that was going to occur today or tomorrow. Is that correct? Okay, and I believe that we attempted to allow victim allocution to proceed via Zoom, but the victim's family was unable to manipulate that technology. Is that correct?
Yes.
Okay.
And, um, my victim coordinator started with Pamela Powell, who's going to speak on it. And, my victim coordinator spoke with her. She recognizes it was her mistake and understands that we can proceed to that.
Is there a request for victim allocution over the phone to be projected in the court? Any,
No, you don't.
not at this time? Okay. All right, then there being nothing further, then we're adjourned in this hearing. Court's going to stand in recess until 1:30. We'll continue the criminal docket.